What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. Random Live. Juneteenth. Let's go. Yeah, I think I have 3 courts that are on right now. Not a lot's going on. So, I decided to wet everyone's whistle this way. Just do a random live in the middle of the day. I got a bunch of random stuff for you. First one's a little bit longer over here in Judge Elmore. It's a good one. I tried to look up facts of this case, and the only article I could find on this defendant was behind a paywall, so I couldn't read it. So I don't really know what happened. She tries to tell you what happened. Judge isn't happy with her. You'll see. All right. What's the line? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
The state of Michigan versus Miranda Joy Teresa Warner. This is file 24-13766FH. Appearances, please.
Joanne Gary, Chief Assistant Prosecuting Attorney for the People.
And I'm Jeff Harrison. I'm here to be on this board. Just with the table.
Thank you. The court also recognizes here today Mr. Charles Kennard, an agent from the Michigan Department of Corrections, standing in today for Mr. Potter, who prepared the pre-sentence investigation report. We'll begin by asking the parties if they have any other amendments or any amendments or corrections to the report. Ms. Carey.
Thank you, Your Honor. I did receive and review the report. I do not have any corrections or additions.
Mr. Harris.
I have no proposed changes here.
Okay. All right. Well, let's take a look here.
My audio seems really off. Is it my headphones or is it off for you guys as well? I don't know. It's just I keep getting weird feedback. So it might be my mic. Hopefully you guys can't hear it.
When we look at a pre-sentence investigation report, there's a reason why a lot of information is requested. It's so the court can fashion a sentence that both fits the individual and the offense. And I don't know why, but beginning on CFJ 284, beginning on page 2 and 3, I don't have any information. And I'm going to ask, why did the defendant not talk about employment, salary, how much money does she make? I've got some information here about some issues, medical and physical. I've got no idea if she was on medication, if she's receiving treatment for those. I will note that there was a letter provided to the court from a physician at the University of Michigan in Ypsilanti. Don't know. Anyways, the point here is I don't know much about the defendant. According to this, she doesn't make any money, which I highly doubt is true. Right? No?
I've not made any money since May of 2023.
You don't do real estate?
Well, that's what my career is, but
Okay.
I got sick last July, and it put a stop to everything that I had on the table. My gallbladder ruptured, I guess, and they had to remove it, and my body didn't handle it well. And I started getting better, and then we went on this trip, and things got worse, and I did this with therapy 3 times a week, so I can't really do work yet.
All right. So if we
All right, so right off the bat, she's saying she doesn't make money whatsoever. She doesn't make any money. Now, when I was doing my research on her, I did find her LinkedIn page, and it looks like she's in real estate. So, and that's what the judge found as well, which, yeah, doesn't really make a lot of sense when she says she makes no income. But this happened at a ski resort. She's at a ski resort with no income. So you can see why this is kind of confusing for a judge. The whole thing is she contradicts herself every time she opens her mouth. Rachel, thank you so much. Yeah, you're welcome. You're welcome. Don't thank me. Thank the holiday. Ooh, that sounded terrible. Yeah, that sounded terrible, especially with what the holiday means. Yeah. Okay. Well, thank you. I appreciate the super chat. All right, let's go.
You went on social media, you don't still run a social media page about being a real estate agent?
That's my main page now, yeah.
Okay,
I will
all right.
continue to do it.
all right. So if you've got other issues and conditions, I don't see any of those here. Let me ask you a question. Were you drinking alcohol on that day?
Absolutely not.
Okay, so if I were to call the sheriff deputy who is here today, they're not going to tell me that you drank alcohol on that day. In fact, they tested you at the jail and you
Yeah.
had some in your system. And if I call the owners of Cabernet to the courtroom, they're not going to tell me you were drinking that day?
No, I was not
Okay.
drinking.
All right, well, I think that's worth checking into. Because I know a lot more about this case. I'm just gonna cut to the chase. I'm gonna allow you to take some time here and you're gonna fill out all that information. And I'm gonna highlight for one thing, when we come down to talk about this case, you attached a letter to the report. And it says you have the right to say what happened. Do you know in that letter, I want you to find for me, and point it out to Mr. Harrison, where in that letter you told me what you did? Not 2 pages of saying what everyone else did. I want to know what you did.
Because at that time, it was happening, I didn't know I was doing it. I mean, I know now, I tried to watch the videos, but I can't because my behavior was absolutely atrocious.
It was. You told your children that you regretted having them.
I've not said that, I don't know, but if I did, I mean, I'm glad I couldn't get through the case then. But I mean, my children haven't said that I said that, and
I know, but I know the people who were there, and I've heard people talk about this.
okay,
So you drove through the parking lot, ripping up the strings with the metal post.
Yep.
That wasn't in there. There wasn't the hitting or slapping of somebody, which I've
It
seen
is
on
in there.
video.
Then I had to pull forward. I didn't hit or slap him, but I accidentally hit her, but I thought I was hitting a guy. I didn't even know it was her. And as for,
Okay. Well, okay. Well, I want to know more information.
All right. I'm going to go back to my previous point. She contradicts herself every time she opens her mouth. I didn't hit or slap anyone. I mean, I accidentally hit her, but I thought it was a guy. Yeah, that means you hit somebody.
Because I can tell you, when I read this on last week, I was like, yeah, this woman doesn't get it. And so right now, you all and Mr. Harrison are going to take a couple of minutes. I'm going to give you 15 minutes. Might be a little bit longer. You're going to fill out all that information. I need to know, are you on medications? Do you have any of this record? So you had apparently some kind of closed head injury. No, it says not a closed head injury. It just says concussion.
well, it's not a concussion anymore. It's just the past 3 months.
Yeah, well, I don't know anything else about that. Yeah, and you know, obviously it was your daughter who called the police that day, right?
Oh, my
No?
daughter said nothing that happened, what they said that happened to her. My
Okay.
daughter did not call this, she had no idea what was going on, she was terrified. All 3 of them were, all 4 of them, because we had her friend.
Were they terrified of you?
No, they were afraid of what was going on, they had
So-
no idea why it was happening.
So we're gonna take some time. We're gonna let you guys fill this out. And we might set this for a show cause as to contempt, because I don't think you're being truthful.
I'm being 100% honest. I
Okay.
swear to God I am.
Then great, then you're gonna be fine. But we're gonna set it aside and have you come back up here. And we're gonna put the videos on, because now it's gonna be a challenge to whether or not you're contempt of court. And whether or not what you're telling me is true.
Okay,
Right?
well, the parts I did see, I can tell you parts of those short parts I saw the videos where I remembered and where I don't, well,
How do
I
you
don't
not
know about
remember?
parts.
How do you
Pardon?
not remember?
I don't remember most of it. I remember only what I wrote down. And I'm in
Well,
therapy
but-
trying to get the memories back.
Here's what I'm gonna focus you on. What you wrote down was very, very detailed until one moment in time. And that's when you acted out. You blamed everybody in your statement.
I didn't
You
blame
talked about,
anyone.
you talked about your boots coming off on the hill, the strap on your snowboard, what another guy did, what another guy
That's
did,
everything I
Yeah.
remember from that day.
but you don't remember.
I
when-
don't even remember if there was my kids anymore from that day. None of it, and that was the first time.
All right, well, we're gonna take a look at this and we're gonna find out what we're going to do. Do I give you a delay of sentence? If I do, based upon what you tell me you don't work and you don't make any money, but I think you have a social media page where you talk about your mortgage,
No, this isn't Judge Oakley. This is Judge Elmore. I saw your first comment. And I just let it go because I was just thinking maybe you mistyped it. But yeah, this is Judge Elmore, not Judge Oakley.
Real estate.
real estate business.
And that was shown, my last close was April or May of 2023.
Okay,
Anything else I've shared since is other agents with their permission.
okay. And can you afford to do trips? Are you taking any vacations?
No, that was the first time we've ever taken them on vacation, not just because of money, but because I've been afraid to do anything with them.
Did you take them anywhere else just around that time?
Maybe family, I
Take
don't
them to
know.
Chicago the week before?
Oh, she took us to Chicago, yes.
See, I'm looking at
Well, the
this.
boys didn't get to go, they went to Chicago with their 12. It was for my daughter and I to see a play.
So you're gonna fill out more information, because right now what I see is somebody who, when I looked at this, here's another thing that you said that upset the court. Let me find it for you.
Yeah, he already knows
Alright.
what he's looking for.
What
Not a
occurred
good
on
sign.
January 3rd, 2024 cannot be written by hand in the amount of time I've had to complete these packets. If need be, I'll write all the events down. Well, then you later on did. And in it, one moment here. Right now, I can't, I'm not looking for the words that I had here, but a statement that you made, but I can tell you through the 2.5 pages, I wrote down, this had nothing to do with what you did. All you did was point fingers at everybody.
But I didn't. I said that I hit somebody. I said why we're fighting. I just explained what happened. I'm not trying to place blame on,
Right.
like.
Okay, well, let's see what we're gonna do. We're gonna take 15 minutes. You're gonna fill out the information. If I ask for that information and I told you to fill it out, you are going to fill it out.
I don't remember not filling something out, so
It's okay. I accept that, and thank you very much for the apology. I do appreciate that. But I can't give you a sentence without knowing the information. And the fact that your attorneys didn't help you fill out the information doesn't help me either. They should have gone over it and said, you need to fill out this information. And I've also talked to the probation officer to help fill this out. You got a ways to go. You told him you didn't drink. The deputy's here to tell me that you had alcohol and that they tested you at the jail and you tested positive.
I didn't get tested at the jail
Yeah, they
for
did.
alcohol.
Is there a test?
I got a DNA test done, that was
In her
it.
booking information, but yes.
Yeah, you
She
did.
has to be tested.
I
You
did
did.
not get a test. I got a DNA test, that was it, a swab on my
Oh,
cheek.
I got it. I understand you're gonna go with that, and that's fine. But you had consumed it that day.
I did not. I
Okay,
did not
okay,
drink
okay.
alcohol.
All right. So You're gonna fill out the rest of this information. I've seen the videos of what happened.
It's horrible.
I know.
It.
I know.
I know. I scared people. I mean, I was scared though. I don't mean
I
to
know,
scare
it's
people.
okay.
I didn't want to hurt anybody. I didn't want to make anybody have to do with any of that.
We're gonna have you take 15 minutes and complete the information here. When you don't complete the information that I asked you to provide, that means that I have to somehow believe you and without any information. And I need to know that. For instance, this information about the treatment that you've mentioned. I need to know that because then that makes me, when I look at that, go, oh, well, this makes sense. But none of it's in here. And you're gonna go fill it out right now. Because that helps me give the sentence and determine if I'm going to give you the delay. All right, thank you. We're adjourned.
Thank you. Your Honor, I need a little more than 15 minutes. I have Zoom.
Oh, she just stepped out.
All right. So this is it's about 45 minutes later. They come back. She calms down a little bit. It's not as wild as part 1, but I wanted to show you guys the conclusion. But yeah, thanks everyone for hanging out.
All right. Yeah, go ahead and grab her and we'll take care of Miss Borner. Thank you.
Rachel, thank you so much for the PayPal. I appreciate it. Thank you so much. That's awesome.
People, the court recalls the case of People of the State of Michigan versus Miranda Borner, file 24-13766FH. The court you may be seated. The court recognizes all parties present. The court recessed earlier this morning are again present, including Ms. Carey on behalf of the people and Mr. Kennard on behalf of the Department of Corrections, the defendant and her counsel, Mr. Harrison. All right, when we were last up here earlier, we were talking about the pre-sentence investigation report. Mr. Harrison, since you're standing up, why don't you go ahead and tell me where we're at?
Your Honor, I did obtain some more extensive information with regard to her current treatment.
Sure.
I've shown it to Mrs. Carey. If I may approach and show the same to the court.
You may, thank you. Ms. Carey, I've had this handed to me by Mr. Harrison. Have you seen it?
I did.
All right, have you gone over it? Any objection to those making those changes?
No, Your Honor.
Okay.
It doesn't mean a whole lot to me, but no.
All right, well, I appreciate it. I'll tell you it does to me because when I looked at the defendant's behavior, I wanted to have some idea of where it came from. That's really what I wanted to know today. And this helps me. This is the kind of stuff that
I've been yelled at by a judge before. My when I was going through my divorce, the judge yelled at me, and yeah, it wasn't good. I felt terrible. But yeah, that's a story for another day. Let me know if you guys want to hear it. It's kind of interesting, funny, but not really. It might bore you all.
I would need to know. So, Mr. Kennard, I'm going to provide this to you, and I'll allow or ask you all to make the changes to the pre-sentence investigation report. And basically, it shows health conditions, work issues, and diagnosis, and probably even more importantly, medications. And some of these medications do give me some, do help me quite a bit. All right, so Mr. Harrison, when last we left and I interrupted and derailed us, do you have any other amendments, corrections, or objections to make the report, sir?
I do not.
All right, allocution then, sir.
Well, I too, to be honest, was or am, I suppose, concerned with regard to the incident in question and the events that took place. And I think it often behooves me in my position to give the court a clear understanding as to why. Why did this happen? Why did it happen this way? Why did my client in this case, Ms. Werner, why did she behave like that on that day in question? And I struggle with trying to do that, to trying to explain it. So I don't think I will. I think I will just say this, Your Honor. I've talked to her spouse. who was involved in the incident as well. She believes that this had something to do with perhaps an as yet undiagnosed mental health condition. We're not sure. The doctors aren't sure. She's currently waiting placement with a new therapist and counselor. Frankly, she's pretty excited about having that opportunity. She's also mentioned that she's had issues regarding her short-term and long-term memory. Well, that too would be consistent with someone who, after the fact, being asked to create a narrative is unable to do so. And the reason I chose that word with particularity, Your Honor, is I don't want to leave the court with the impression that it was her choice or that she had any purpose in trying to be deceptive. She doesn't. She has said today that she deeply regrets her actions. They're embarrassing. We have watched the videos that you mentioned, Your Honor, on a couple of different occasions in our office. She's not been able to sit through the complete videos on each occasion because she is mortified that the person that is obviously her was behaving in that way on that date and time. So the search for the existential question why, frankly, is not going to have a satisfactory conclusion, I don't believe, in this one particular instance. I wanted to have you review that medical information because as you could see, she suffers from a myriad of concerns with regard to her mental health and perhaps a myriad of concerns with her physical health, not to mention the fact that she is a survivor of leukemia. And we're not supposed to say survivor because it's technically in remission. But as you can see, Your Honor, that's not a current issue she's dealing with. I struggle with this as well, Your Honor, because overall, I think her instincts were in the right place. She felt that she and or her children were being threatened somehow, and she reacted in the way, at least in the intentional way, that you would have a parent react. The fact that it merged into this sort of irrational, unexplainable situation, notwithstanding, that just says to me that there's at least a glimmer of recognition on her part of a genuine, what she perceived to be a genuine threat. And I'm much more comfortable having discussed it with her prior to today, Your Honor, and a little bit more today, that she does recognize the wrongfulness of her actions and that she ought to have a sanction imposed for having committed that behavior. Now, let's circle back to that one in a little bit. As you know, the proposal here is for a delayed sentence. I believe that when we entered the plea, and I believe now even more fervently, that that is appropriate under these circumstances. The reason I think that, Your Honor, is that I think she owes the court and the people of this county the obligation, the responsibility to take care of whatever her mental health diagnosis turns into. Now, I'm not putting a large burden on her shoulders because, as you can see, she's already heavily involved in her mental health and trying to control it as much as she can. I'm not sure at the end of the day how all of the stories that were told that day fit together. I'm also
All right, I was trying to wait for the defense attorney to finish, but he's been talking for too long. Yeah, I don't think anyone understands how all the stories fit together because none of them really make sense. But there was a question, and I wanted to pause it to make sure I answered it. Someone said, "Is there a victim in this case?" I think there is, or there was, but they're not. They might not be pressing charges. So I think it is just the state against her, she was just acting a fool in the parking lot of a ski resort. Apparently she was, they're saying she was drunk. She's saying she wasn't. She drove through, parking dividers, causing damage. Then she slapped somebody. So yes, there's a victim. But they don't really bring that up. And this case is about this sentencing is a deferred sentence. So they're trying to get her to take accountability for what's going on, and she's not. But yeah, well, at least she didn't at first. She slowly gets there, I think. I don't really remember.
Also not sure that there's anything that I could say that might persuade the court that this was not entirely an intentional act. Okay. The important thing for me, and I guess what I would emphasize to the court as well, is that she herself is aware of the fact that she's responsible for her actions on that day. And she doesn't seek to shirk that responsibility. And she's more than willing to provide you with the proof that you need to be certain that she's got it under control by serving her delay of sentence probation as proposed in the PSI. Thank you, Your Honor.
Thank you. Ms. Carey?
Thank you, Your Honor. I find this case to be quite frustrating. I did agree to a delay of sentence, and I'm going to stick with that, and I'm going to start with that because of her lack of any prior history. So I do think it's fair, although I do think the period of probation also is appropriate. There was no mention at the time of being assaulted in the parking lot. There was no mention at the time of falling and hitting her head. There was no mention of that. There was only really.
She didn't go to see ski patrol.
She didn't go see ski patrol. We double checked on that. She didn't call the police herself, but numerous people called because of her behavior, not because of anybody else's, because of hers. And when the police did arrive, she was worse. She was combative and belligerent and quite horrible to them. So, and I saw the list of medications. It's her list. It's not from a doctor. There's no proof of it. And I take that for what it is. There's no indication in the 5.5 months that this has been pending that she's done really. I don't know what counseling she's had. I don't know what treatment. I don't know how often she's going. I don't know what she's done to address what she claims are these mental health issues that cause this. And that frustrates me because she's had time. She's had time to get us more than what she's given. She's had time to show us that she's taking this seriously and that she's addressing the issues. And frankly, I don't see that. But I think a delay of sentence with a year will give her that time to show that she's taking it seriously and that she's not going to do this again. And this is really, she put a lot of people in danger. She scared a lot of people. And this kind of behavior, frankly, is just not acceptable no matter what the reason. And I would ask the court to consider that. And I would also ask the court to follow the delay. Thank you.
Thank you. All right, Ms. Porter, you have the right to make a statement if you choose to do so. Is there anything you wish to say today now?
I want to apologize for everything that I caused. And I'm willing to do whatever it is that you guys need me to do. And I'm very sorry to the officers I came in contact with that night. Every one of them. I feel sorry for even the people that didn't know what originally started. Like, I feel bad for all of them. And I'm just very sorry.
So again, and I'm going to cover a few things and then I'm going to tell you what the sentence will be. The first thing is, and I did find what I was looking for earlier, and I'll tell you, it really stuck with me. It's on the second page of your statement. I'd rather not go into detail about the attack at this moment due to time.
No, I don't think it was a police officer. I think it was someone that worked at the resort. I don't. I keep calling it a resort. I'm not exactly sure it's a resort. She was snowboarding, so I keep calling it that. I don't know Michigan that well, but apparently it was an area that had some hills. I don't know if they even say the resort's name or the place's name. So, but yeah, so just a resort.
There, if you want it.
Oh, I wrote the attack
Yeah.
specifically.
But hold on, and I'll tell you, on these 3 pages, the question is what did you do and what happened? And I told you to maybe speak with Mr. Harrison about where it was. You described what you did. It doesn't really appear there until it's the moment you're in the jail.
Well, when I thought about it out there, I did
Yeah.
realize there could have, when I had said that people came through, like I was fighting the people, like, and maybe I didn't put that information in there.
Okay, but the point there is that just tells me, I just don't know if you get it. I will say, I know all about the event. The owner was standing right there. The 2 owners were standing right there.
And then one of them took one of my children.
Yeah.
And he wasn't supposed to.
But you also were
I'm
out of
sorry.
control.
I know.
So I'm gonna tell you, what I've seen here today, or I'm sorry, what I've seen in this report is not what happened. Here's another thing. I don't need to drive, is what you said, because I've got multiple licensed people. No, you drove through the barricades with the vehicle,
Yes.
but yet you told here that you didn't drive.
No, but I wasn't going to the truck to drive. I was going to the truck originally to change. And then I was going back to the truck with my kids because of what happened originally.
So why did you drive through the barricades?
Because they were surrounding our car and they wouldn't stop trying to open all of our doors. That's why, and I finally had all of my kids in the car and I just wanted us to get away. That was it.
But here's the thing. Why did that all start? Why were they there circling around you?
Because the initial man that did approach with me from behind when I was trying to get into the truck originally to change, when I was by myself. And that freaked me out and I'm like, okay, we're not dealing with this. So I went back up and I'm like, we gotta go. Like, no, leave everything. She'll come get it. Like, we gotta go. We all gotta get in the truck. And then by the time I got down there again, I don't know if it was the same guy or a different guy. But
By the
he
way,
did it again.
it was an employee. He was one of the guys on the camera.
Yeah, so he,
Yeah, he was trying to stop you from hurting your kids and hurting
I
yourself.
told him that I had not drank. I told him that I also wasn't the driver. I told him that I had 4 licensed drivers. So I had 2 teenagers that had permits. Well, one of them didn't have a permit yet. I lied about that when I told him that. But just to make it clear that I was not intoxicated and that I wasn't the one driving anyway.
Again, back to point A. She contradicts herself every time she opens her mouth. Maybe not every time. Just kind of like I just contradicted myself. I had 4 licensed drivers in the car. No, I didn't. I only had 3. The 3 of them had permits. That's not a licensed driver. Yeah, they can drive with you in the car, but it doesn't sound like you're at any state to watch them drive. So I don't think that would fly.
When this all started, Alyssa and one of our sons were still on the lift. We were not supposed to be leaving yet.
Okay.
I just wanted to change my clothes because things were too confusing. I couldn't move right.
I've seen the videos.
I've seen
The
them too.
only person that was, and I saw, by the way, I'm gonna note, there are a lot of other videos out there. It wouldn't take long for us to have a hearing and to subpoena the other people who have the videos. I could call right now on the phone and have them here in the next 30 minutes. There was one person who was out of control, and it was you. Nobody else. Anyone else interrupting was trying to stop you from driving because you were
I
yelling.
didn't become disrupted.
Do not talk. Maybe you're used to that somewhere else in your life. When I'm talking, you do not.
I really want to see the videos too. That's why I was looking the story up. First off, it took me a while to figure out how to spell her name, and then I finally found an article, hoping that there would be some video of it, but it was behind a paywall, so I couldn't see it. But there was only one. I could only find one article. Yeah, but we all want to see the videos.
The court sentences the defendant as follows. The court places the defendant upon a period of probation with underneath a delay of sentence for 12 months. That is pursuant to NCL 771.1, parenthetical 2. The court assesses two $68 state minimum fees, a $130 crime victims' right fund fee, a $300 court cost. I'm going to set the fines here at $1,500 and attorney fees at $300 and a supervision fee of $30 a month or $50 a month if there is any electronic monitoring. The court adopts the terms or conditions for that period of probation, which are contained on CFJ 145, pages 2 and 3. I base this sentence entirely only on the information that's contained in the pre-sentence investigation report, and particularly the detailed information that's provided not only today by the defendant on review of issues regarding health. And here's what I'm going to highlight. This is what we should have talked about. Ms. Border does have several issues and several things that involve substances and medications, and I'm concerned for her. I want to ensure that she is following that policy procedure. The person I see here today, however, which I'm not going to use as my sentence, you are not the person you portray on your social media that my office helped me look up. But I'm sentencing you only on the information that's contained in this report. And really what's lacking in your description of the event. And I can tell you, the very last page of your report seems to suggest to me, I didn't know what I was doing, is what you said. First you say someone smashed your face in the cement. I don't know about that, but anyways, that part of the story seems to have changed. But here's what you said. I kicked away from the door in restraint that was going to break my ankle, and I did my best to sit up. And then continues, I did not know I was actually with officers until I was strapped into a chair and made eye contact. Which means, what does it really mean? It means that you denied resisting an officer. You thought you were just resisting somebody else. So the real question is should I just withdraw your plea? Because right there, you just denied that you did anything wrong. That is what has set me off when I reviewed this. You said, I didn't know what I was doing until I was in the police station and I was strapped to a chair. You denied everything else, which means you never have yet acknowledged, well, maybe you have a little bit today, what you did wrong. When I see that, you know, each one of these attorneys knows, when I see in a PSI that the defendant denies doing anything wrong, the first question is let's withdraw the plea and send you to trial. Mr. Harrison, is that what your client wants to do?
No, it is not.
I didn't think so. Again, the court finds the terms and conditions for probation that are listed on CFJ 145 are appropriate. The court sentences the defendant to 2 days in jail with 2 days of credit. Because the defendant is placed upon a delay, the court does not need to go over the advice of rights. Ms. Border, had you not said that last sentence, and had you filled out all the information, it wouldn't have been as rough today. Anya, my point here isn't to be mean. It's that when I look at this, I don't see a defendant who thinks she did anything wrong. And so far, a lot today, especially the 2.5-page statement, did not help you. We are adjourned.
Your Honor, I'm sorry, is there a DNA fee?
DNA, well, we don't
We don't do that.
do a DNA fee if there's a delay of sentence, because it's still a deferred sentence.
I just wanted to
All
make
right,
sure.
thank you. We're adjourned.
Yeah, I will admit I did not look on Facebook. I looked on YouTube and then I just Googled. I've been on Facebook for a total of 1 minute over the last 3 years. So yeah, did not look on Facebook. All right, that one's done. Before we go, Jedi, thank you so much, Jedi, for the 5 gifted memberships, and welcome to all the new members. Thank you so much, Jedi. That's awesome. All right. Next one. I think we're going to Judge Garcia next. This is a weird one. It's a weird one.
Actually?
Yep.
Yeah,
Judge Garcia, let's go.
All right, go ahead. Quest.
So the monthly rent is $700, and or the amount behind is $4,900. That's from I think November 1st until June 1st. So it doesn't include prorated rent for June.
I'm sorry, November 1st to May 1st?
Sorry, yeah, correct. It's for 7 months. Sorry.
May.
Yeah, sorry. Does not include June.
Okay, that's what I thought you said,
Sorry.
but I wasn't sure. Okay, all right. So Miss Clanton, y'all look identical.
Thank you.
All right. So Miss Clanton, do you agree that your monthly rent is $700?
But you didn't know that. She doesn't agree because she's been in the home for 14 years and she's been paid it off through the prior owners, Masi and Carlos Lopez. So, I mean, and we have like a sale, she was to pay $600 a month through the prior owners to them. Like Masi, the prior owners sent us to them with false,
Slow down,
words.
slow down.
I'm
Okay.
sorry, but they said she was gonna get the title to the home.
And she didn't.
When she went and signed, she had signed a lease,
So,
and I was not there, so yeah.
and unfortunately, they got her into a situation now. Okay, well, hold on real quick. Let me see what Quest has got right now.
So we purchased the house from Maisie or Mossy, whatever.
Mossy,
Mhm. And so, but we
When did
purchased
you purchase it?
on August 14th. And Miss Clanton was aware that we purchased it from them because I met with Miss Clanton personally at a Starbucks in October and showed her a lease agreement. And we told her we could work with her to purchase the house from us because we were the new owners, but we're going to put you on a lease. If you make payments, because she said she didn't have a big monthly down payment, but she had lived in the house, so we weren't going to kick her out. We said you could live there. We bought it in August 14th, and I can show you the deed if you need to see it.
Of 2023.
Of 2023, and I didn't put the lease effective until October, giving her time because she didn't even have the $700 to give me because we were willing to work with her. She signed the lease. I didn't print it out. I apologize, but I can show you the signed copy on my phone.
Yeah,
And,
she's gonna need to see that.
Absolutely. And so she signed it at the Starbucks with me, gave me the money order. That was the only payment we received from her.
Okay.
She never paid any other payment. I have text messages between her that she's been really sick. And then, so I've been working with her, not wanting to evict her.
It locked.
Oh,
You
I'm
pushed it.
sorry.
No, that,
So, I apologize. if
No,
you
you're
print it
fine.
out as well.
all right. So Miss Clanton, it looks like your mom is signing. I don't know if she's aware or what's going on that she's signing it, but I just heard her agree that she did meet with her at a Starbucks. Okay, so that's valid. And did you sign anything at the Starbucks?
Yes,
Okay,
but
well,
I
there
did
we
give her
go.
700 rent, thinking it was November, not October.
And right here we have the lease and it does state that her monthly rent is $700.
So, I'm sorry.
Go ahead.
Go ahead, I'm so sorry.
And I want you, Miss Clanton, to look at this real quick. Just, it's her phone, but just kind of scroll through it. Second page, it does have the amount of rent. Watch out, Constable, if your
I have
fingers.
the purchase agreement through the prior landlord and where they paid $600 a month for 132 months and then $700 a month for 48 months. You know, and she has all that documentation for it. My dad died last year, so it was in April.
21.
It was in April April, yes, and then it's just a lot because I don't understand how they could pay that much money. And they signed for $100,000. They've done paid well over $100,000 for this home, and it's crappy. I'm sorry, excuse my language. It's really crappy, and I've tried. I want to go and tear it all and fix it and redo the walls and redo it all. And I've told her this, and she's my dad passed away there, and that's where she wanted to pass with him. So I'm just trying to figure out.
I understand, but you also got to remember your mom is signing paperwork.
Yeah.
And I'm sorry that she may not know. She should have told you because now we're here. And unfortunately, I can't negate or vacate anything that she has signed because you weren't there with her. Okay, she's still of sound in body, unless I have a mental paperwork from a doctor stating she has no capability of signing. Then, and I know she is. And right now, and what I'm looking right now is on the property code. I'm sorry, on the property records, Bexar County property records, because that's how I know who's the rightful owner at this moment in time. Okay, and right now, and just like she said, August the 11th, give or take, it's going to take a couple of days for her to get the printout, but it went from Magley and Marcel Lopez to Trust or Quest Trust Company.
Right.
So what happened between that transaction is something you're going to have to hire attorneys for if that's what you think you need.
I spoke to David Schaefer, and he was supposed to be here, but he's out of town. And he's supposed to step in on this because it's 14 years of her paying, and then she has documents and everything.
Well, Mr. Schaefer knows how to do these cases, so he knows your rights after today. If y'all have any rights or if there's any avenues you can take, he's aware of those avenues. He's practiced in my court 100 times already, so he's well aware. Go ahead, Quest.
Well, I just had a question. There's also no power at the house. So CPS has removed the meter from the house, and I got confirmation on the phone. I tried to get them to send me something in writing, but they wouldn't. So I'm just wondering, like, what?
Yeah, now we're bringing another concern.
Because, so the house, and I do have pictures, it's in horrible condition. So it's a property that we own, right? It's our asset, and it's not being taken care of. There's no property. The neighbor next door keeps calling me about just bad things happening. And so I just don't understand. I don't know what we can do about that as well.
Okay, go ahead.
First of all, yes, the property's in bad shape. I was gone for 6 months due to CHF, congestive heart failure. And it got, before they purchased it, it was already damaged. I had a slumlord that never wanted to fix it. His daughters, one lives in England, one lives in Colorado, and they never would come fix anything. So I would have to, under my fixing income,
But right now, Ms. Clanton, are you staying there?
Yes, ma'am.
Are you staying there with no electricity?
All right, none of this really matters. They want the property back, and they don't have a right to be there. So the judge is right that this doesn't really affect the case. But she's about to say no electricity. That's bad on the landlord if they're the ones who cut it off. They can get in trouble for that. I don't know if that can stay the eviction though. I don't know. I should know. I watch enough of these cases.
No, ma'am. I am not staying there with no electricity. I'm sorry. I'm at my daughter's house right now. The reason I did turn off the electricity is because I have 2 sons in that house that I'm trying to get out of there.
Okay, well.
40 and one's 42.
Oh man, I forgot that twist. The person that was living there turned off the electricity. It's her kids that are causing all the issue. I forgot that twist. Let's go.
Okay. And she's just like,
Oh my God.
I'm with you. I'm with you.
I said, you stop. No, I did.
I'm hungry.
They're horrible. I love my boys. God forgive me for saying that, but I would not wish my boys.
That
on no
one threw
woman.
me for a loop. I was not
I'm
expecting.
sorry, I don't wish my sons on no woman because they're horrible. I have 2 that are good, and I have 2 that are no.
I'll make sure I
look at
delete
their
this video.
girlfriends and go, have you lost your mind? Have
Okay.
you lost your mind?
All right, so let's get back to business. Okay.
If for some reason I do have to move, I need to the end of the month to remove all my personal belongings, and I need to try to clean up some of the mess that my boys left there.
Okay. Are you willing to give her the 2 weeks to move out? to avoid a judgment, or are you seeking judgment today? It's completely up to
I
you,
know.
but I'm putting that on you.
I have a, like, you will be at all of your, like, you will hand me keys, no boys in the house, because
Yeah,
I
no
need the
boys,
house
no
with
boys,
without
no
boys.
No,
Okay,
because they believe me, they don't like that heat.
okay.
I would hope.
Also, my house got robbed
Okay.
while I was gone. That front window I replaced was broken. I replaced the whole entire room. Did some work inside the house.
You look like you got something to say. What's going on?
I do. I have a crew ready to come in and turn that into a group home. I'm saying, like, I mean, we could all make money. Just saying,
Well,
like,
y'all discuss whatever y'all want
that's
outside,
another
but
subject,
That's another subject.
your mom said she's gonna move out in 2 weeks.
Yes.
Again,
But
it's a, go ahead.
what happens if the boy, like, mom moves out, but the
Gotta
boys
evict
are
them,
still
right?
there? Then I have to come back and evict, because I think on this,
like-
it states Barbara Clanton and all other occupants to try to cover the boys as well. So that's
So-
just my
the
concern.
boys, I'm sorry.
I don't know what I need to do to make sure.
Okay, well, let me rephrase this. It
Okay.
just says Barbara Clanton. It does not
It
say
doesn't?
all occupants. No, ma'am.
Oh, it should have said on all other occupants.
That's what I
It
said.
says
A lot of shouldas over here.
It just says Barbara
Great,
Clanton.
okay.
So I guess that's, I can't give you any advice on that.
I
You
can
already
give her
know where
some
that
advice.
goes.
Yeah, I
Carroll
do.
County Sheriff's Department will move them off.
Well, mom's reassuring you.
Right.
And usually mom works
I'm
better
a-
than
I'm
the
a
law.
I know, I
I'm
know.
a
You know, that
retired
chancla is just, you know,
I'm a
but
retired bounty hunter out of Austin.
well, there you go. Mom, you better get them out. Do your bounty hunting things and let's go.
Well,
Okay.
one of them, Christopher Clanton, does have a restraining order on that address.
Okay, thanks,
You
mom.
might want to speak with mom. Mom's
Okay.
got a lot of things going on. Okay, mom, we're giving you 2 weeks to move out. If you move out within the 2 weeks, then you will walk out without an eviction. Okay, but you also got to remember, she's got to protect her
I
interests.
know, I know.
And then if the boys are still there, it might be an issue. I don't know.
This is gonna be great for lunch. I'm
I
sorry.
live in Camelot Phase 2. I can get them removed.
Okay.
Mom. All right.
So
2
are
weeks.
we resetting for
We're
2 weeks?
resetting for 2 weeks. Yes, ma'am. And then if y'all want to speak outside, y'all are.
All right, all right. Yeah, I completely forgot about that twist at the end. Oh man, that was good. That was funny. Needed that. Needed that. All right. Jedi. Yeah, I don't know what was going on with that mic. I'm guessing it was at one of the booths, either the plaintiff or the tenants were messing with the mic, or I think they were messing with the table because you kept hearing a knocking as well. So I think someone was just nervous fidgeting. But yeah, that was bad. All right, next one we are going. I think we're going to Washington. I can't remember what the name of this judge is, but this guy, this is a little bit of a slow burn. A little bit of a slow burn. All right, let's go.
We are ready on Mr. Butler. Mr. Butler, if you want to click on unmute by clicking on the screen and then click on the little red microphone button that says unmute. It's on the upper right hand corner of the screen. If you can't unmute, you can get the officer's attention. They can help you. But if you click on the screen where my face is and then click on the upper right hand corner, there's a little red microphone button there. There you go. And Your Honor, this is Drannon v. Butler 4A02122625 is on for Raymond, and then there's 2A0060432, 4A0153937, 3A0314353, 3A0259603, and 2A0727866 on for review. Proceeding on the arraignment, there is Drannon v. Butler, your true and correct name.
Yes, it is, sir.
And your date of birth is February 22nd, 1987.
Sorry.
Earlier, we discussed your rights at arraignment. Any questions about your rights that I wasn't able to answer?
Yes.
Do you have questions about your rights at arraignment?
Oh, no, you answered.
Yeah.
All right.
And Your Honor, I've gone over the charges, the maximum penalties, any mandatory minimum penalties. We'd acknowledge receipt of the complaint, waive from our reading, and ask to enter plea of not guilty.
Plea of not guilty will enter. I do find probable cause to detain as to all counts. What is the city's recommendation regarding release?
Good afternoon. For the record, Cynthia Chenwell for the city of SeaTac. City's requesting bail amount of 500 cash or bond on each of the 6 cases. Given defendant's warrant failure to appear history, the city believes the defendant's a high risk of future failures to appear. Given his history related to obstructing, resisting, city believes that he's a high risk of failing to comply with court orders and conditions of sentence or release, and is a risk of disruption administration of justice, asking the court to, of course, find the basis to set the bail or bond at this point on the review matters as well.
Any objection?
Your Honor, Mr. Butler is hoping the court releases him. He's indicated he does have housing now. We are asking for a direct appointment. He's indicated he has housing now. He said he would show up for court out of custody and has every reason to show up for court out of custody. If the court does not release him, we're hoping the court sets a date relatively soon later this week.
In addition to the new case that was just arraigned on, there's the Seattle Municipal Court case from February. I think that post dates, and that's still pending, but I think that's post dates the last case in this resolution on the last case in this case, of the last CTAC case. Let me see. Oh, maybe not. No, that actually predates resolution. However, I have concerns about Mr. Butler's ability to abide by court orders. Pardon?
I will abide, miss. Give me one chance. Just
So
one.
the problem is we're here with 3 new charges.
I promise.
And you were ordered not to commit any new criminal law violations, and you were ordered not
Give me one
to.
chance. You never give me a chance. One chance, just one chance.
I'm gonna jail in the amount of $500 each case. Splitting that up, 300 on the trespass, 100 on each of the other charges.
All right. Before this gets good, yeah, it's about to. This guy is just gonna start running his mouth. Just you wait. I've got another kind of random couple videos I put together. I was just looking to see what courts were open. So he's like, am I gonna go catch up on court, or do you guys want to hang out? So what do you guys want to do? You guys want to take a break and come back later for my live tonight, or do you want to stay here for another 20 minutes? Let me know. No, I'm still going to go live tonight. I'm saying I've got another, random couple of clips I put together just in case there weren't that many courts that were open right now. There's still only 3. And so I was either going to go catch up on those 3 and, just play the video tonight, which I already have a video for tonight, or I can play the 20-minute bonus clips that I have ready right now. That's my my question. I can do a poll. It's just there's only 5 minutes left of this, so the poll is not going to be up very long. But I'll put it up.
Additional conditions that you attend all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes. And do you still receive mail at the Compass Center downtown?
No, ma'am.
Did you say no, ma'am?
Mm-hmm. Yes, I said no. I didn't hear what you said initially. You said five.
Do you still receive what?
I want to bond out. I want to call my mom and get her to tell her to get me out of here because I don't belong here and I don't want to be here.
I think it's a total of $3,000. You have 1, 2, 3, 4. You have 6 cases and it's $500 per case.
Why don't you help me? They keep doing this to me over and over. And why don't you help me and just let me be free? They came and tackled me in this.
No, do not talk about the facts of the case.
Well, I'm going to talk to the judge. She can help me and free me.
I've offered you help. I've given you information for our community court resource center on more than one occasion.
No, you haven't, miss. No, you haven't. And I just
on the orders. I'm pretty sure I have.
this keeps my family's having problems without me, and this keeps sweeping me off my feet. I really need.
Mr. Butler, I've already made my decision. The problem is, I look at your history. For one thing, you have 6 cases here. 6. 4, 5 of them are in review.
Because when I plea out on a case, they continue it for 1,000 years and hang it over my head. Who does that with a misdemeanor? Who does that?
Municipal courts.
No, they don't. I'm from Chicago.
I'm from
When I
Chicago
give you the
too.
time, it's over with.
Telling you what happens in Washington State. I'm looking at your history. You have warrant activity on almost every single case you've ever had, other than the ones where you've been held in custody.
How many times do you think I've been assaulted?
I've made
I've
my.
been assaulted like 3 or 4 or 5 times, and I didn't even call the police on anybody.
Mr. Iannotti, when would you like to set this over to?
Ms. Ron, are you going to be the trial judge?
Set it in the next, either tomorrow or Thursday.
When do we set it for Thursday? There are already 8 on tomorrow. 8 people, not even 8 cases. Okay, and I will direct a point if I haven't already said it. Additional conditions that you attend to all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes, and use only your true legal name and date of birth. And have
I done it, Ms. Ron? Have I done anything to you personally? Because these things, all the protesters are out. How come they're not in jail?
Have no contact with SeaTac International Airport or the rental car facility except for valid travel purposes.
Can I talk to Mr. Lonnie for a minute, Ms. Ron, please? Am I excused?
Come and talk to you, but not right now.
All right, let's see where the poll is, because this video only has about 30 seconds left. Today, all right, wow. From the people in the chat, I thought it was going to be closer than that. But all right, I'll play the random clips that I have.
Mr. Butler, we'll see you on Thursday.
Okay, I'll see you. Yes, ma'am. I'll see you on Thursday.
Thank you.
Wait, give me a second. Let me talk to Mr. Long. Okay, bye bye. See you on Thursday.
And I'm not, Mr. Butler, as indicated, I'm not going to be able to talk to you right now, but I will come and talk to you.
I just got a few questions about the bond. How much is it entirely?
3,000 is what the court indicated.
3,000, and how much do I have to post? 300?
That's between
or
you and the
30,000?
bonding company. Most bonding companies charge 10%.
So it's about $300.
Yes, that's between you and the bonding.
Oh, okay, thank you.
That last little soundbite there. The bond's $3,000. How much does that mean I have to pay? 300 or 30,000? Like, wow, yeah. All right, next one. I can't let this play further because my outro will play. Random. I even titled it random, and put my intro on it because I'm a jerk like that. Well, we're starting with Shackelford. All right, here we go. You guys voted for it. Let's go.
Kowalik.
Oh.
We are? All right, Mr. Kowalik, come on up. Okay.
You got it also.
Okay, we're back on Mr. Kowalik, 231476. Let me get the complainant present. All right, so Mr. Gazicki, before you, Mr. Kowalik, advise if he would like to have representation on this. I did go over Mr. Kowalik's rights with him, correct? Mr. Kowalik, you have to say yes for my court report. Okay.
Okay, just a little background information. This defendant was in front of Judge Shackelford last week, and he fired his attorney, and he decided he wanted to represent himself. But at that hearing, the victim, she's going to pop up on screen here in a second, she said during the last hearing that he keeps contacting her, and for some reason the judge or the court wasn't getting the no contact violation report. She wasn't receiving them, so they came back because they were properly filed, so she saw them. So now he's back, and he decided pro se was not the way to go. So that's where we're at. Just a little background.
Okay, And so here we are, we've got the complainant present. You've seen what the allegation is, Mr. Gazicki, for purposes of arraignment on this allegation.
What's that, Your Honor?
How is he pleading today? on
Not
this
guilty to the accusations, Your Honor.
Okay, so I'll enter a not guilty plea on his behalf on this the allegations in this violation. And we'll have to set this for a hearing. So Ms. Davidoff, my understanding is you're awaiting some paperwork from the complainant on this case. Is that accurate?
Yes, Your Honor.
All right, Mr. Kowalik, I'm guessing you might have some paperwork you want to get to your attorney as well. Is that accurate? Okay. All right, so we're going to set this hearing as soon as we can.
Since I'm back in this case, I have a discovery order that's been signed for the prosecutor.
Okay, you can approach.
Yeah.
All right, I've signed the request for discovery for Mr. Gazicki on this case. And as to bond, Mr. Gazicki?
I'd ask for a personal bond. These are just allegations. There's been no physical contact. And I am sure that when we have the hearing, we'll be able to dispute any kind of accusations as far as Mr. Kowalik making any kind of comments to the victim.
David?
Your Honor, I asked that the defendant be remanded. I think that, yes, they are allegations. However, there is some allegations of witness intimidation as well. And I do think that the complaining witness is in jeopardy. I think her safety is definitely at risk, and in turn, the community safety is at risk. So I do ask that he is remanded based on the allegations that are present.
All right.
These are all unfounded allegations, and like I said, they're verbal. Mr. Kowalik, if need be, has police reports filed in other agencies against the victim for similar offenses. Since there's been no physical contact, I think it'd be extremely harsh just based on an accusation from a person that we don't even know if her the original complaint is legit or not, because we haven't had a trial. I mean, it's sufficient enough to start a proceeding. It's sufficient to start a proceeding, but I don't think it's a remand would be appropriate in this case, Your Honor.
Okay. Mr. Kowalik appeared today. There's no allegation that he's had any physical contact with the home or the party. Is that correct?
That is correct, Your Honor, but at times, these verbal allegations do lead to real life harm, as well as intimidating the witness from showing up to court and continuing on through these court proceedings.
Okay. Well, we've come to court before on this, and Mr. Kowalik has alleged that he's receiving contact from her, and I don't know if that's true or not.
I've never received any evidence of that, Your Honor.
Mr. Kowalik, listen to me.
Yes, Your Honor, I'm sorry.
You cannot contact Miss McCall. Do you understand me? Listen to me. You can't go by her home. You can't drive by her work. You can't, is there a child in common?
Yes, but I don't even
Yes.
talk to him yet.
He has nothing to do with it.
All right, so he's not, so he's not contacting the child.
No, his girlfriend keeps contacting me and going off on the phone at me. They keep calling me and telling me that I won't make it out of that courtroom on July 26th when it does happen, that he will not get locked up that same day, and he will make sure that he handles my mouth and shuts it for me.
He said that to you, or she said that to you?
Yes. They both called me on Lisa McKenzie's Facebook, but it's under Lisa Kowalik. I literally just sent the screenshots to Mrs. Jessica. They just sent to her all of the screenshots. He threatened that he said give that bitch her dad's ashes and all of her possessions.
All right.
So she
All right,
drops the
Ms.
charges
McCall.
on me.
Give me a second, Ms. Kowalik. Let counsels look at this. Ms. McCall. I mean, are you looking at them? Do you see, are there phone calls being made?
There are text messages. I don't have time to check the manner. I don't have the ability, I should say, to check the phone numbers and see who they're to. Mr. Kowalik's phone's been off for quite a while.
But Mr. Kowalczyk, you understand, like when I say
Oh.
contact, you can't have someone else contact either. Your girlfriend, is that your girlfriend? No, listen, I'm talking now. Nobody can contact Miss McCall. You can't, your mom can't, your cousin can't, your girlfriend can't, your best friend can't. Do you understand me?
I understand.
If there is any allegation of future contact, I'm gonna continue bond for now. But if I get a single allegation, if another report's written or more documentation is provided to Miss Davidoff that there has been, no, listen, don't talk. I don't need you to talk. Listen to me. If there is another allegation and she's got some documentation, which I've not seen any of this, these are just allegations. But if there's another one, I'm not gonna have a choice. I will revoke your bond and you'll sit in county while this case is pending. And Mr. Kowalczyk, I don't even know that we have a trial date on your case right at the
July
moment.
26th.
It's July 26th?
I thought that's what we had.
27th, maybe.
26th,
July
27th.
26th.
It's July 26th. 27th is a Saturday. Okay, so you're gonna sit in jail for the next month while this case is going on if I have any allegations of contact. Miss McCall, I have a bunch of court officers that are retired Detroit Police Department. I've got other officers that are retired officers. They are very competent. Nobody is going to be threatened or harassed in the building or the parking lot.
Been harassed this whole time and he's still getting away with this. I'm literally a victim and he keeps putting me through this over and over and over again. I have all the proof on Jessica's phone. I just sent it to her through my email.
Well, we're going to set it, we're going to set it for a hearing. Okay? I'm going next Monday. So we'd have to do it 2 weeks on July 1st.
I'm waiting for some documents too. It's gonna take a while to get mine. I know that.
Miss McCall, listen to me. If there is a phone number or a phone call that you receive, I don't know what we have to set it for a hearing is, right to a hearing on it. If there is anything, Miss Davidoff, and it is provided to you, I'm asking that you contact the court immediately so that we can have an emergency hearing on whether or not Mr. Kowalczyk needs to be remanded.
It's been numerous times I came up to that courthouse and I made reports and nothing.
Yeah, we'll talk about this after. Understand me? Do you understand me? I've got a chance to review this. I will review it at the hearing, Miss McCall. Mr. Kowalczyk's not coming near you. He's on a GPS tether. He's not coming near you. He's not going to call you. Nobody else is going to call you. He is on a tether. We can have the locations checked. He has a zone he's not to go near, and that's where you are.
Okay, so you said that he's not supposed to contact me through third party, yet he has his girlfriend in there and he keeps contacting me.
He will not be contacting you through anyone. We're gonna have to do this morning of July 1st, and we're gonna do it in person on July 1st, and we'll set it at 8:30 a.m. 2 Mondays from today. July 1st, and we'll do it right at 8:30 at the court. And if we're doing a hearing, you have to come in person. Okay, Ms. McCall? And you can work that out with Ms. Davidoff and the advocate, Ms. Dennis, Mr. Kowalczyk, and Mr. Kowalczyk's girlfriend. If you see Ms. McCall in the building, you do not even make eye contact with her. Turn around and sit on the other side of the court or ask to be put in a room, or you know what the safest thing you can do is to keep everyone safe? Come sit in here. Okay? Because then I see you.
Yes, Your Honor.
All right, we're all set. We'll have a hearing on it on July 1st. Bond continued for now.
I'll speak
with Sarah in the
Yeah,
breakout.
Ms. McCall, we're gonna put you back in a room so that you can work out the details of your next court appearance. All right, I have Mr. Anderson. Do you need to speak with your client?
I do, but I think we'll also need an interpreter.
We have an interpreter. She's in with the jail right.
All right. Yeah, that kind of changed the mood a little bit. The This is the difference between judges. Judge Simpson would have remanded that guy until that hearing came up. And then he could have proven if he was innocent or not. But yeah, that's scary. That's scary. And with those allegations and what was said, yeah, I think he should be in jail until July 1st. I really do. Especially after seeing his actions in court the last time. I believe her. I do. All right, next one. Let's move on. Let's move on.
Sellers next. Sellers, good morning. You're here for first appearance accused of one count of breach of peace, one count of giving false ID. Ms. Sellers, you're being brought back today to be made a plea offer to try to resolve this case. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Ms. Sellers in case number 24293MM. She's going to plea of no contest to the charges as listed. The understanding she'll be sentenced to 60 days in the county jail on disorderly conduct, 9 months on the false ID. They'll run concurrent. She'll have 9 days jail credits, and she has signed her plea waiver form, waiving the right to jury trial and call witnesses. And Mr. Sellers, that'll take care of his case.
May I say, sir, that I really did not give out false identification. I just want to go ahead and I just want to let you know that I changed my name back in 2018. I remember I come up here and I got the waiver and stuff like that, and I really did change my name. These people even went as far as cutting up my ID, and my little cousin, my cousin Kyle Mabry, I don't know if you remember him, but he's the one who actually walked up to the truck right there at the bridge in Cottondale by the bread factory or whatever that place is, the truck depot, and got my ID, and then somebody left it there beside the bridge. You know, that was years ago or whatever. But I just wanted to validate that with you, sir, because I really did change my name. So I really, and he was like, that's a country singer's name. I'm not even gonna run that. I was like, well, I mean, there are videos, country music videos, you know, if you want to call it country music video. But
thank you, sir.
Hang on. Ms. Sellers, you got to tell me if you want to enter this plea or not. The plea agreement is 9 months in jail with credit for 9 days. Plea of no contest. Is that what you want to do?
I reckon that'll work, because I mean, that's the only plea I'm gonna get, I reckon.
Ms. Bremer, is that agreeable with the state?
It is, Your Honor.
Ms. Sellers, I'm going to accept your plea of no contest to the charge of breach of the peace and giving false ID to law enforcement officers. The judge of guilty sentenced you to 60 days in jail on the breach of the peace, 9 months jail concurrent on the giving false ID, $370 court costs and fines will be imposed. And Ms. Sellers, I do wish you the best. Have a good day.
Yes, sir, you too.
Thank you. That's not right. No. Hang on a second. All right, next case we have is India McKenzie. Ms. McKenzie, good morning. You're here for first appearance accused of one count of petty theft. Ms. McKenzie, there is probable cause for this charge. I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Me fail English? That's impossible. Yeah, Ralph. One of the best Simpson quotes
Your Honor,
ever.
I spoke to Ms. McKenzie in case number 24292MM. She's going to plea of no contest to the charge of petty theft. The understanding should be sentenced to 60 days in the county jail. She'll have 9 days jail credit. She waived the right to jury trial and call witnesses. I don't recall if there was restitution owed in this case, Ms. Bremer. I usually make notes, but if there is any restitution owed, or what is that restitution, Ms. Bremer?
We don't have that amount at this time yet.
MB, thank you so much. I haven't even seen you in the chat, MB, but thank you so much for the super chat or the PayPal. I appreciate it. Are you in chat? If I missed you in chat, sorry. But yeah, MB, thank you so much. I appreciate it.
We just asked reserve on the restitution, then, Your Honor. I don't think she has any criminal history, Your Honor. She is on a PTI in Washington County. You know, so I have the court to decide the adjudication.
Yeah, I don't know that she's telling you the truth, or I've been provided the wrong criminal history, one or the other. According to what I was provided this morning, she has several prior charges, including some recent stuff in another county.
She has a PTI. She over in Washington County.
Can they send me back to Shipley? Can they send me back to Shipley?
She has a PTI that she's on, and she has multiple other charges. Let's see. 23 MM. She had a prior theft, but I couldn't tell if she's adjudicator or not. That's why she's got an intimidation or threat with serious bodily harm in Washington County. It's a 23 case number. She's got the one she's on PT. Hang on just a second, McKenzie. I'm trying to look at your history. Ms. McKenzie, I'm trying to make sure this is you, because if this is not you, then that plea offer might need to be adjusted. But the criminal history the jail sent me this morning shows several prior charges. Is that not accurate?
Judge, I think I just figured out what the issue is. I can't see them sometimes because they're when she was a minor. So I think that maybe when they were all, she just turned 18 in November. Just turned 18 in November. So I think a lot of these issues may be under CJJ. That's probably why I didn't see them.
Yeah. Yeah, she's on PTI now for child abuse. So, Mr. McKenzie, knowing all of that, is this the plea that you want to enter?
A bond?
No, 60 days.
In 60 days? Okay. There's no program option. There's no mental health options.
Given your history and the fact that you have charges pending, the only plea offer today is the one that you've been made. Now, you very well may be entitled to a bond, and I'm glad to set your bond if you prefer. But I do not know what Washington County will, let me finish, stop interrupting me. I do not know what Washington County will do, whether they will violate your PTI or not and hold you without bond. I have no idea. But I'll set your bond in Jackson County if you wish.
There's already a bond set, Your Honor.
Okay, even better.
Yes. Do you want to post that bond?
You want to post the bond or you want to take the offer?
The bond.
All right.
And it can be lowered or?
No, it's not gonna be lowered.
I forgot, what is the number?
2,500.
Okay,
Good luck to you, man.
thank you.
I apologize, Judge.
All right, we had to get a little Florida action going on. Still missing Judge Van though. Haven't seen him in a while. All right, we're moving on to the last clip of the day. I believe it's the last one. I don't remember what it is, but it's 1/3 of the video left, so I'm gonna assume it's the last one. I am still going live tonight, normal time, 8 o'clock. I do have a video ready for a release. That'll probably be about 3. Got to space them out a little bit. All right, let's go.
Joseph Leech.
Yes, sir.
Mr. Leech, at this point in time, there have been charges that have been filed. The county attorney's office.
This is for you, 12 strings at Twilight, or should I say Jay Regeers? Well, what was it? I always mix. What was your first name? I don't remember what it was. And I don't want to say what I think it was. I want to say, nope, not going to say it. All right. This guy's very interesting, though. Not Jay Regeer, this defendant. Again, a little bit of a slow burn. Just wait till he starts talking.
Office as the prosecutor has made the same. However, there's been a computer problem, and we do not have those charges so that I can go through those with you. Subsequently, very limited information available that apparently there is an aggravated battery against a law enforcement officer.
Yes,
interference with the LEO.
Yes,
and criminal use of a weapon and a criminal trespass.
Yeah, Lexa and Johnny, that's what I thought it was. First off, I didn't want to be wrong. And second, I didn't want to say that today of all days. Just that word. Yeah, we're not going to use that word today, even though it's not in the same context.
I don't have the specifics on all that,
yes.
but I do know. Actually, I was going to go through and try to explain the problem that the court is having. We do not have these back, and we do not have these on file. I need to be able to read to you with some specificity what's been filed with the court. Yes, I do not have that capacity right now. So I'm going to simply set bond in your case, take recommendations from the state, and I'll also take information from you. But I am, yes.
I would very much like to request an OR bond. I have a warrant out of Pawnee County for a probation case that I need to work on, that I need to go deal with. If you could OR bond me to that, then they will release me right back to you as soon as that case is done?
Okay, just a moment. Let me get some input from the county attorney's office as to how they deem the most appropriate means and manner would be. And Mr. Regier.
Your Honor, it is the state's understanding that this case has been filed, although there may be certain technical difficulties as referred to by the court. I do have a copy of the information in front of me if the court is prepared to accept a proffer under these circumstances. If not, the state would be requesting the matter be set over to the next first appearance docket, or in the alternative, if the court is determined to set bond at this time, I am certainly in position to make recommendations to that effect.
Thank you for the proffer. However, I do not have the judge assignment going forward into the future. So I believe I'm going to need to have Mr. Leech once again appear this coming Friday at 1:30, the next first appearance date. That's Friday at 1:30. Now, court does wish to, Mr. Leech has advised that he does request an OR bond in some amount so that he may answer for probation issues in Pawnee County, Kansas. Recommendation from the state, Mr. Regier.
Your Honor, the state's understanding based off my notes is this is a case that involves multiple felonies. If the court is not prepared to conduct a full first appearance hearing, the state would be requesting at a minimum $7,500 cash or surety with all standard conditions, including no contact with the victim or possession of weapons. Besides that, based off the state's understanding, this is a defendant who I understand has a history of felony convictions as well, including felony making false information, felony theft, and felony attempted murder in the first degree, as well as for specific facts indicated in the affidavit, which I'm prepared to refer to if the court so wishes.
Thank you, Mr. Regier. Mr. Leech, based on information that...
Excuse me, can I speak?
Yes, sir. Mr. Leech.
The attempted murder was an accident I had in my car, that I hit somebody with my car. The violence on the officer.
All right. No, hold on. I don't know why I didn't have this loaded. Allie, where were you? She always tells me to keep this ready to go.
Answer, sir, please. You every time you open your pie hole, you get it worse troubled. So stay the course.
This weekend was not on the officer. I kept telling him to shoot me, because she won't get my trust if you don't.
Thank you, Mr.
He
Leech.
attacked me on said due point. I am trying to find out how to deal with this situation the best way I possibly can and not cause any more legal issues at all. I do not wish to disrespect the court or the law. I'm a firm believer in both. I also am a vet, so I have no issues respecting the law. You know,
thank you,
my
Mr.
wife is here in Augusta, or is in Augusta, living on the street where we came to try to get through here and go to Oklahoma.
Okay.
She is on the street by herself with our dogs and no money, no place to go, and nothing but issues, and I cannot seem to get anybody to help. I am just trying to simply get someone to help her. I understand I have legal issues, and I understand that.
Thank you,
this may
Mr.
be
Leech.
aggravating.
Mr. Leech, thank you for the information. I do believe that an appropriate bond in your case is for the amount of $7,500, cash or surety. The court overrules your motion for an OR bond. So the court does order $7,500 cash or surety bond. The court does order you to reappear on Friday, June 21st at 1:30.
All right, this Friday. Wow, this isn't that old. This just happened maybe Monday. Okay, all right. He's got a quick turnaround. All right, I'm gonna let this video play out, guys. Thank you so much for hanging out with me today. Thank you Jedi for the gifted memberships. Thank you Rachel for the super chat. MB and I think it was, let's see, it was MB PayPal and where'd it go? And Rachel, it was Rachel. Thank you so much, everybody. You guys all are awesome. I will see you later tonight or in court. Until next time, bye.
June 21st, 1:30. Anything further, Mr. Regier?
Your Honor, as the court has already observed, this is a somewhat unusual situation procedurally as far as any purported technical issues are concerned. I'm not sure if the court wants to address the issue of counsel for the defense one way or the other at this time.
And I'm not going to appoint counsel at this point. I'll let that be determined at the time of first appearance.
Very good, Your Honor.
There being nothing further to come before the court is in recess. Have a good day, Mr. Leech.